If you're facing divorce and considering going through mediation, it's important to keep the following things in mind. First and foremost, it's in your interest to have a fierce advocate on your side fighting for you and presenting your story to the mediator. Mediation is a process where you and your family law attorney meet with a third-party attorney, typically very experienced in the area of practice that your case is in a divorce case, it'd be a family law attorney, and the other party meets with their attorney to come together and try and reach a resolution. Your attorney can help you prepare by building out a strategy for what you're willing to do and not willing to do in order to reach a resolution on your case. Additionally, we found it very powerful to draft a mediation statement on behalf of our clients, to present our client's story about what it is that they're willing to do or not willing to do to reach settlement in their case. This is an opportunity for your attorney to draft a powerful story, not only of the facts of the case, but also how the law and relevant issues in your case should be applied. This can be presented to the mediator days before, and it gives them an opportunity to review your story and what you would like them to know before the process even begins. At mediation, the mediator will meet with you and the opposing party, hear both sides' version of the case, what it is that you're hoping to achieve, what you're not willing to, and what you're willing to do, and then go to the other side to see where they are at. Typically, the first hour, 2 hours of the process is really the mediator getting to know what you want and what the other side wants. The rest of the day is spent seeing what give and take there can be in order for the parties to potentially reach a resolution on all or many of the important issues that come up in a family law mediation. These issues include custody, visitation, division of assets such as retirement accounts, real estate, the marital home, personal property, vehicles, other stuff that the parties have acquired during or may have possessed even before marriage. At the end of the day, if you and your spouse or the opposing party in your divorce case can reach a settlement on all issues, the mediator and the attorneys can draft up that settlement agreement and present it to the court. One important thing to keep in mind is that if you reach an agreement on all issues or even just some issues of your case, if the parties execute a signed settlement agreement for all of or some of these important issues, that can be presented to the court, potentially be held against the other party, or move to enforce that settlement agreement. Unfortunately, at the end of a mediation, even if the parties reach an agreement on all issues, it's not the end of your divorce. One or both attorneys will need to take time to draft a formal divorce decree, visitation and custody plan or schedule if children are involved, and also prepare the child support guidelines. Once the parties have put all of this together, it can be turned into a formal document and presented to the court for a final order being entered, at which time your divorce can actually be finalized. Hope this video has been helpful talking you through some of the important steps in preparing for, going to mediation, and what your divorce case will look like at the conclusion of mediation. If you have additional questions about this or family law in Oklahoma in general, we encourage you to subscribe to our YouTube channel or reach out to us for answers to your questions. If we're the right fit, we'd be happy to be your fierce advocates.